Contempt, at its most basic definition, is a feeling. It happens when one person feels that another person or another thing is beneath them, that it's worthless or deserving of scorn. But contempt is more than a feeling. Contempt is a power. It allows a judge to put you in jail without a trial or a jury, without even setting foot in his courtroom. According to the words of the Constitution and the right to trial by jury, one man acting as prosecutor and sole judge shouldn't be possible in America. In the early 1800s, it was rarely used. And when it was to put away a man in prison, Congress acted against the judge who did it and even passed a law to make sure it didn't happen again. But judges interpret laws, and they eventually interpreted Congress meant something else than what they wrote. Contempt is stronger than ever and putting more people in jail on a daily basis. This is the story of how a restraint on the power for one man to decide another man's freedom became a green light instead, with one man having his freedom taken away simply because he missed an appointment, and a judge called it contempt. St. Louis, 1826. Luke Lawless had practiced law in the federal court for years. He represented clients in land disputes, the tangled cases that filled the docket after the Louisiana Purchase, when the United States had to decide which Spanish and French land grants it would honor. James Peck had been on the federal bench for 4 years. President Monroe appointed him to the newly created District Court for Missouri in 1822. He was the only federal judge in the state. One of those land cases involved Julie Soulard. Her husband, Antoine, had served as Surveyor General for the Spanish government in Upper Louisiana. In 1796, the Spanish lieutenant governor granted him 10,000 arpents, about 8,000 acres, as payment for his service. Antoine died in March 1825, nearly 30 years after the grant, and Julie was still fighting to confirm the title. Lawless represented the family. In December 1825, Judge Peck ruled against them. The grant was invalid. Lawless believed Peck had made errors of fact, errors of legal reasoning. He wrote a letter to the Missouri Advocate, a St. Louis newspaper, listing 18 points where he believed the judge got it wrong. He signed it, a citizen. April 20th, 1826, the first day of the next court term. A deputy marshal arrived at the office of the Missouri Advocate. He handed the editor a rule: appear tomorrow, 11 o'clock, to show cause why you should not be held in contempt for publishing a false statement tending to bring odium on the court. The next morning, the editor appeared before Judge Peck. He argued the judge had no jurisdiction over the matter as a contempt. Peck ordered him detained. The editor would remain in custody, Peck made clear, until he revealed who wrote the letter. The editor gave up the name, under oath, to the judge. Peck released him. Then came the rule against Lawless, whose name the editor had just provided, requiring him to appear forthwith to show cause why he should not be held in contempt for false and malicious statements, to show cause why he should not be suspended from practice. There would be no jury, no trial in any ordinary sense. The same judge who felt aggrieved would decide guilt. That same judge would impose the sentence. Peck found Lawless in contempt. 24 hours in prison, 18 months suspended from the practice of law. 18 months. Lawless was a lawyer. That was his trade, his livelihood. For a year and a half, he could not appear in federal court, could not file a motion, could not argue a case, could not earn a living in the profession he had chosen. The Fifth Amendment says no person shall be deprived of life, liberty, or property without due process of law. Lawless had no jury. He had no trial. The judge took those actions on words he read in a newspaper. But surely the judge must have read other words found in a document he was sworn to protect and defend. Surely he must have read the fact that the Constitution guaranteed jury trials, not once, not twice, 3 times. But Judge Peck focused only on the newspaper. He called it contempt, and contempt, he said, was different. Congress, however, thought differently. In 1830, they voted to impeach Judge Peck. The articles were clear. Peck had abused his power. He had imprisoned a lawyer without a jury trial for conduct that wasn't criminal. He had used contempt not to maintain order in his courtroom, but to punish criticism. The Senate trial lasted weeks. Peck's defenders argued he was protecting the dignity of the court, that judges needed some power to maintain authority, that Lawless had gone too far. The Senate vote was close. 21 voted guilty, But one more, a total of 22, voted not guilty. 21 to 22. 5 didn't vote at all. Peck survived. That was January 31st, 1831. But just because more senators decided against convicting than for it, didn't mean they thought that what he did was right. 2 days later, February 2nd, Representative James Buchanan of Pennsylvania rose in the House. Buchanan had been one of the managers who prosecuted Peck before the Senate. He had argued for removal. He had lost. Now he introduced a bill. By February 5th, the Judiciary Committee had reported it out. By February 10th, it passed the House. By March 1st, the Senate. On March 2nd, the President of the United States signed it into law. 30 days, from acquittal to statute. A lightning-fast law, bipartisan agreement that this could never happen again. Congress couldn't remove the judge, so they removed the power. The language was specific. Summary punishments for contempt of court shall not be construed to extend to any cases except the misbehavior of any person or persons in the presence of the said courts, or so near thereto as to obstruct the administration of justice. But it wasn't just about parties in front of the judge. The misbehavior of any of the officers of the said courts in their official transactions, and the disobedience or resistance by any officer of the said courts, party, juror, witness, or any other person or persons, to any lawful writ, process, order, rule, decree, or command of the said courts. And the Judiciary Committee made the meaning clearer. The proposed bill restricts the power of punishment for contempt to the only cases where it can be properly exerted, vis-a-vis to those acts which directly obstruct the physical performance of the judicial functions. Physical, not criticism in a newspaper, not a letter signed, a citizen. Physical obstruction of the court's work. But the committee went further. They named the deeper problem, the one Lawless had faced when he stood before Judge Peck. The great principle which ought to be engrafted upon the law is that a judge shall never be the accuser and the judge in his own cause. For decades, that's how it was understood. But that understanding would get lost, and seemingly intentionally. Toledo, Ohio, 1914. Judge John Killitz was 55 years old. He'd been a federal judge for 4 years, appointed by President Taft. Before that, he ran a newspaper in Iowa, then practiced law in small-town Ohio for 16 years. He understood the press. He understood small communities. He knew what newspapers did. So what he did next to a different newspaper seems inexplicable. The Toledo News-Bee was part of the Scripps newspaper chain, known for championing working people. The News-Bee had taken the side of Toledo's citizens in a bitter dispute over streetcar fares. Toledo, 1914. The streetcar company wanted to set fares at 5 cents. The city opposed it. The streetcar company went to federal court, asked Judge Killitz for an injunction to block the city's 3-cent fare ordinance. Killitz sided with the company. In September 1914, he issued the injunction. The Toledo News-Bee had been covering the dispute for months. When Killitz ruled for the company, the News-Bee didn't stay quiet. They published a cartoon, The Streetcar Company as a Dying Man in Bed. Friends gathered around, one saying, "Guess we'd better call in Doc Killitz." More articles followed, more cartoons, all criticizing Killitz for siding with the company. Killitz waited 6 months. Then he acted. He held the newspaper and its editor in contempt, not for any outburst in his courtroom, but for a series of articles and cartoons about a pending case that, he said, were stirring public hostility to the court and resistance to its orders. The newspaper was publishing in Toledo. The articles appeared in print, read by citizens in their homes and on the street corners. Freedom of the press was a right, wasn't it? In December, Killitz tried the case himself. The judge who felt contemned, judging whether he had been contemned. No jury. He imposed a substantial fine. The case reached the Supreme Court. The question was simple. Does the 1831 Act allow this? The newspaper's lawyers pointed to the statute's plain language. In the presence of the court are so near thereto as to obstruct the administration of justice. The articles weren't published in the courthouse. They were published in newspapers, distributed across the city. The government's lawyers offered a different reading. The articles had a tendency to interfere with the administration of justice. They might influence public opinion. They might make it harder for the judge to do his work. The Supreme Court sided with the government. 7 justices to 2. Chief Justice Edward White wrote the opinion. He acknowledged the 1831 Act was passed to restrict contempt power, but then he rewrote its meaning. The test, White wrote, is the character of the act done and its direct tendency to prevent and obstruct the discharge of judicial duty. It didn't matter if the judge was actually influenced. It didn't matter if the publications changed anything. The tendency was enough. So near thereto no longer meant geography. It meant influence, and potential influence at that. Justice Holmes dissented. Justice Brandeis joined him. When it is considered how contrary it is to our practice and ways of thinking for the same person to be accuser and sole judge in a matter which, if he be sensitive, may involve strong personal feeling, I should expect the power to be limited by the necessities of the case. The same person, accuser and judge. Holmes's final analysis: action like the present, in my opinion, is wholly unwarranted by even color of law. Holmes and Brandeis were in the minority, but the Toledo newspaper decision didn't come from another planet. The groundwork had been laid decades earlier through two surprising cases. One where the Supreme Court claimed an origin for contempt found from other places than the Constitution, and another involving a violent confrontation between a Supreme Court justice and his former colleague, with one of the men's wives even being forcefully held down. Ex parte Robinson. A district judge in Arkansas disbarred an attorney for contempt. The attorney's offense: speaking to the judge in a tone the judge found angry, disrespectful, and defiant. The case reached the Supreme Court. Justice Stephen Field wrote the opinion. Field acknowledged the 1831 Act. He agreed it limited the lower federal courts. Congress created those courts, he wrote, and Congress could define their powers. But then Field said something else. The power to punish for contempts is inherent in all courts. Its existence is essential to the preservation of order in judicial proceedings, and to the enforcement of the judgments, orders, and writs of the courts, and consequently to the due administration of justice. Inherent, not granted by Congress, not defined by statute. You can't even find it in the Constitution. But Field found it. He said it was always existing. Inherent, belonging to the courts by their very nature of existence. Field even expressed doubt whether the 1831 Act could limit the Supreme Court at all, since that court derives its existence and powers from the Constitution. But Field didn't mention that word. Contempt is found in the Constitution. I'll break the tension. It's not found there. Nowhere. But despite that, the Robinson decision actually sided with the attorney. The disbarment was improper because the 1831 statute allowed only fine or imprisonment, not disbarment. But the seed was planted. And as you'll see through other episodes and other issues and other cases, the court does this quite often. It'll actually side for the individual, but put in words and sentences that creates the power for other courts to side differently next time. The lawyer won, but the judge put in words that can be used later. It's precedent. The seed was planted. Contempt power was inherent. Congress could regulate it, perhaps, but something inherent cannot be abolished. That's what the judges say. And who decided it was inherent? Judge Field. The word would echo forward. 14 years later, the power found its teeth. Ex parte Terry. David Terry had once been Chief Justice of the California Supreme Court. Now he was an attorney, married to Sarah Althea Hill, embroiled in a lawsuit over her claim to a silver mining fortune. The case was before the Federal Circuit Court. Justice Stephen Field, the same justice who wrote Robinson, was presiding. The Circuit Court operated differently than it does today. At the time of this case, it involved a Supreme Court justice riding circuit in his assigned territory, hearing trial-level cases with a district judge. This was in addition to their normal roles, overseeing cases at the Supreme Court level. California was part of Justice Field's circuit. Justice Field had actually served on that state's Supreme Court, and he had done so with Sarah's lawyer, who had sat with him on that bench. When the judges announced their ruling against Sarah in her claim to the mining fortune, she erupted. Accusations, even shouts that Field had been bribed. Field ordered the U.S. Marshal to remove her from the court. Terry, her lawyer, and her husband rose. He declared no man would touch his wife. He struck the marshal in the face. He reached for a Bowie knife. Deputies seized him before he could draw it. Sarah, meanwhile, tried to pull a revolver from her satchel. Both were subdued. The court's order came the same day. Now, therefore, be it ordered and adjudged by this court that the said David S. Terry, by reason of said acts, was and is guilty of contempt of the authority of this court, committed in its presence, and it is further ordered that the said David S. Terry be punished for said contempt by imprisonment for the term of 6 months. 6 months. No jury, no trial, no witnesses called, no defense presented. Terry sought a writ of habeas corpus from the Supreme Court. His lawyers argued he had been imprisoned without due process, without the protections guaranteed by the Constitution. The court denied the writ. Justice Harlan wrote, "It is a settled doctrine that for direct contempts committed in the face of the court, the offender may, in its discretion, be instantly apprehended and immediately imprisoned, without trial or issue, and without other proof than its actual knowledge of what occurred." Terry disputed the court's account. He and Field had a history. They both sat on the California Supreme Court together. But without a jury, the judge's version was the only version that mattered, and the only version that is told today. The 1831 Act had confined contempt to misbehavior in the presence of the court. Terry's conduct fit that category. He struck a marshal. He reached for a weapon. But the act was a response to Judge Peck imprisoning Luke Lawless for a day and disbarring him for 18 months for words in a newspaper. Now the Supreme Court seems to approve of federal courts imposing 6 months in prison on its own authority without a trial by jury. The restraint Congress built seems to have changed with a few decisions of court, and both decisions primarily involved one man, Justice Stephen Field. The Constitution guarantees trial by jury. It also guarantees due process of law. But in 2 court decisions, Justice Field claimed that contempt is inherent of the court. And not only that, a judge can put one away for 6 months without a trial. David Terry was deprived of his liberty for 6 months. He had no jury. He had no trial. The same court that felt offended decided his guilt and imposed his sentence. And then the same judge who sent him away for 6 months was also part of the group that checked his decision. He sat on the circuit court making the judgment. Then he sat with his colleagues in the Supreme Court, checking his circuit court decision. The judge said he could act without other people interfering. No jury. And it's okay. I checked again with my friends. We all thought it was okay. So how could the courts get around a constitutional right to a jury trial, to due process? The answer the court gives: contempt is different. It is not a crime in the ordinary sense. It is an offense against the court itself, and the court must have power to vindicate and protect its own authority. The Constitution does not say the trial of all crimes shall be by jury unless a judge is personally offended. It does not say in all criminal prosecutions except contempt. The courts carve those exceptions themselves. But one case involving one man giving another man a drink stopped contempt's growth, but just for a bit. Nye versus United States. For decades, the Toledo newspaper interpretation stood. The portion that said "so near thereto" in the law passed to constrain contempt meant not geography, but influence. A tendency to obstruct justice wherever it occurred could be contempt, even though the words say geography. But then the court reversed course. The Nye case involved a man accused of using liquor to persuade the plaintiff in a wrongful death lawsuit to drop his case. The persuasion happened over 100 miles from the courthouse. The lower courts held it was contempt. The conduct was so near thereto to the court that it obstructed justice. Justice William Douglas wrote for the majority of the Supreme Court. The question is whether the words "so near thereto" have a geographical or causal connotation. Read in their context and in the light of their ordinary meaning, we conclude that they are to be construed as geographical terms. Physical proximity. That was the plain meaning. The Toledo newspaper case was overruled. The geographic boundary was restored. But Nye fixed only one problem. It didn't say what happened inside the courtroom. It didn't address the power to impose 6 months in jail without a jury. And nothing about the judge, who's acting as prosecution, jury, and the judge all at once. Although it was seemingly geographically constrained, contempt survived. Luke Lawless spent a day in prison and 18 months disbarred for a letter to a newspaper. The House voted to impeach Judge Peck. The Senate came within a few votes of removing him. Congress passed a law in 30 days. James Buchanan, who prosecuted Peck and then wrote the statute, made a prediction during the trial itself. "I will venture to predict that whatever may be the decision of the Senate upon this impeachment, Judge Peck has been the last man in the United States to exercise its power, and Mr. Lawless has been its last victim." The last man, the last victim. The Nye case seemingly restored the geographic limit, but a judge could still sentence a man to 6 months without a jury, so long as he did not sentence him to 6 months and a day. and judges found new ways to break contempt out of that court's chambers once again, with it running wild in current-day America. DeAndre Somerville was 21 years old. He worked in after-school programs for the city of West Palm Beach. No criminal record. He had been selected for jury duty on a civil case. Told to return the next morning at 9. He overslept. Somerville didn't call the court. A police officer showed up at his grandparents' home with a summons. Somerville appealed before the judge, explained he overslept, said he'd never been arrested, never been in handcuffs. The judge found him in direct contempt of court, 10 days in jail, a year of probation, 150 hours of community service, and even told him he had to write an official apology, plus court fees. No jury, no trial, no prosecutor proving anything beyond a missed alarm, and no law against missing an appointment. Somerville later said to his astonishment he walked in the courtroom a free man, but then later left with a criminal record and in handcuffs. After national attention, the judge eventually vacated the sentence and cleared his record. But Somerville had already spent 10 days in a cell. A judge, by himself, decided contempt existed. A judge imposed the punishment. A judge controlled the process. One person. The same power Luke Lawless faced in 1826, the same power Congress tried to restrain in 1831, the same power courts later called inherent. The Constitution still guarantees jury trials, but contempt seems to override it. One man, both prosecutor and sole judge. Contempt. To learn about other quiet mechanisms that can and often do impact your life, and not always for the better, check out my Plain Meaning channel on YouTube for more episodes. And if you watch them all, don't worry, because I release a new one every Tuesday.